so
scared right now. I'm about to
okay. So, all right, listen, turn around for me. I'm going to place you under arrest. Turn around. I'm going to place you under arrest for reckless driving. You're driving way too fast, ma'am. You nearly took out the pedestrian. You're driving 91 and a 35. I can't let you not go to. You have to go to jail for that. There's a line and you cross it.
November 25th, 2025, Florida. A 21-year-old was clocked at 91 miles per hour in a 35 zone 56 over the posted limit and nearly struck a pedestrian in a marked crosswalk. This analysis addresses why the officer had no discretion to issue a ticket, why the DUI charge was correctly withheld, and what the pre-arrest statements produced in a non-custodial roadside context mean under federal constitutional law. The stop was constitutionally grounded before the first word was spoken. Under Delaware v. Prowse in 1979, direct radar observation of a traffic violation satisfies both reasonable, articulable suspicion and probable cause for a stop without any additional inquiry. 91 in a 35 is not a borderline case. The subject made 3 potentially self-incriminating statements before Miranda was read. I had 1 drink, I was just driving fast, and I was running late. None required a prior rights advisement. Under Berkemer v. McCarty in 1984, the Supreme Court held that a routine traffic stop does not constitute custody for Miranda purposes, even if the driver is not free to leave. Roadside questioning during a valid stop is non-custodial. Those statements are fully admissible.
I'm sorry.
Okay, you seem like you're intoxicated as well. Yeah, I'm 10-4. I got 1 in custody. Why are you driving like that? Huh? I'm asking you.
Sorry.
All right, walk over here. All right, lean up against the hood of the car. I'm going to pat you down.
Okay.
You have anything in your pockets?
No, I don't.
Okay. All right, turn around and face me. All right, you seem like you've been drinking a little bit. You smell like it.
Okay, I had 1 drink.
Okay. All right, are you willing to submit to field sobriety?
Yeah.
Okay, turn around. Turn around, please. This is the car. Yeah. I think she's been drinking too, so.
Are you guys really gonna arrest me?
Well, I'm gonna have you do field.
Seriously?
I'm gonna have you do field sobriety. Okay, to see if you're impaired to the point where you shouldn't be driving. Okay, do you have your license?
I do. It's not on me, but you guys can.
Okay, is this your vehicle?
This is my mom's car.
All right, how old are you?
I'm 21.
Okay, stand in front of the bumper. I'm gonna grab a form.
What's your name?
Chloe.
Chloe, just take a deep breath, okay? We gotta, yeah, I know. We gotta do this investigation. So just proceed with it, okay?
Dad, you almost wiped out that pedestrian in the crosswalk back there.
I'm sorry.
Well, sorry is not gonna.
No,
if you hit the pedestrian, you can say sorry you want, but it's not gonna fix the fact that you took out a pedestrian. You know what I mean?
Yeah.
And you're driving like a nut job.
Okay. I'm sorry.
Okay, what is your name, ma'am?
Chloe.
All right, hang on. All right. Are you willing to?
I was going. Yeah, I'm willing to submit.
Okay. Yeah, you're doing 91 and a 35, ma'am.
I'm sorry. This is my mom's car, and like.
And you almost, like I said, you almost took out the pedestrian.
I didn't see the pedestrian, and I'm really, really
Well, you
sorry.
can't see the pedestrian if you're driving like excessive. You know what I mean?
Okay, and
So-
I'm sorry. Like.
Okay.
genuinely.
So you're willing to submit to field sobriety?
Yeah. What happens? Like.
Okay,
I don't want to get like arrested right now.
Well, I'm going to ask you to perform some field sobriety exercises. You have the right to say yes or no.
What happens if I say no?
Well, then, if you say no, I'm going to base my judgment on everything that I see up to this point.
Then I guess I'll say yes.
Okay. So I want you to stand just the way you are. Do you see the tip of this pen?
Yes.
I'm not trying to be a smart ass to you. I'm just telling you. So what I want you to do is watch the tip of the pen with your eyes and your eyes only. If you can't keep your arms down to your side. Okay. I'm going to shine the light. I'm not going to try to put it in your eyes, but I want to see what I'm looking at. Okay. So what I'm going to do is I'm going to move this pen side to side. And when I tell you to, I want you to follow the pen with your eyes and your eyes only. Does that make sense?
Yeah.
Okay. All right. Try not to move your head. Just follow the tip. All right, so I don't see nystagmus, okay? You said you've had one drink?
I've had one drink, and I just was driving it fast because this is my parents' car, and I'm not from here. I'm from Wesley Chapel, so I didn't know, like, I wasn't looking at the speed limit.
Well, I'm not trying to be rude to you, man. The speed limit's the same all over the state.
I'm so scared right now. I'm about to piss
Okay.
my pants.
So,
Yeah.
all right, listen, turn around for me. I'm going to place you under arrest.
Wait.
Turn around. I'm going to place you under arrest for reckless driving. You're driving way too fast, ma'am. You nearly took out the pedestrian. You're driving 91 and a 35. I can't let you not go to. You have to go to jail for that. There's a line and you crossed it. All right. You can walk back here, please. How far is your mother to get her car? How long would it take her to get here?
A while. What's happening?
So we're
right
going to
now?
impound your car.
Well, can you tell me that?
Yes, I will. Please have a seat. Do you have anything in your pockets?
No.
You sure?
No.
You're not sure?
I don't have anything in my
right.
pockets.
All right. So at this time, you have the right to remain silent. Anything you say can and will be used against you in court. You have the right to talk to a lawyer and have that lawyer with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any question if you wish. You can decide at any time to exercise these rights and not answer any questions or make any statements. You understand these rights as I have explained them to you.
Yeah.
Having your rights in mind, you wish to talk to me now.
Yeah. So
Okay.
what happens with this? Like, when do I
Well, I
get
want to ask
bailed
you.
out? I'm confused.
So, why were you driving? I had you at 91 and a 35.
I'm sorry. Like, I don't know.
Why were you driving like that?
I don't
You were running
know.
late to go to a friend's? Is that what you said? Something like that earlier.
Yeah, I'm sorry. I don't know what to say, like, honestly.
Okay, so you're running late to go to a friend's and you were doing 91 and a 35, and this is your mother's car?
So far, we're getting nothing out here.
Is that basically what you were saying?
Yeah.
Okay. So in Florida, there's a new law. It's a super speeder law. If you're doing 50 over the speed limit, okay, it's a misdemeanor. You're going to go to jail. I don't have a choice. I can't give you a warning or a ticket.
Fine.
So I'm just telling you. Okay? Like I can't just let you go when something like that and then
why you can't give me just like a ticket?
because I'm explaining to you. There's a new law called super speeder and you almost took out a pedestrian, ma'am. So you have no business being behind the wheel driving like that. Okay? And if I give you a ticket, you're never going to learn anything.
Yes. What do you mean?
So we're going to be going to the jailhouse.
Like,
I'm gonna search you real
yeah,
quick.
it's fine.
Go ahead and face the vehicle over here. Yeah. You got a bra on?
Yeah.
Nothing stuffed in there?
No.
You understand if you go to jail and you have anything?
I don't have anything.
I'm just trying to explain to you that if you go to
I
jail
don't
and you
understand
have...
why I'm going to freaking jail right now.
Please explain it.
I'm trying to explain to you, if you have anything on you, that's an additional charge, okay? So if you have anything, we can work with that now.
Yeah, it's nothing.
And your stance?
The mandatory arrest turns on Florida Statute Section 316.1897, the super speeder statute. That law makes it a first-degree misdemeanor to travel 50 or more miles per hour over the posted speed limit. The consequence is mandatory custodial arrest. The statute eliminates officer discretion entirely. No warning, no civil citation, no alternative resolution. The officer's statement at sub 158, "I don't have a choice. I can't give you a warning or a ticket," was not a personal decision. It was a statutory requirement. The reckless driving charge under Florida Statute Section 316.192 provides an independent second basis for the arrest. That statute requires willful or wanton disregard for the safety of persons or property. 56 miles per hour over the posted limit and a near miss of a pedestrian in a marked crosswalk is not a close question under that standard. Either charge alone, superspeeder, or reckless driving independently mandated custody. Together they are legally redundant. Both stand. Florida Statute Section 316.1936 prohibits possession of an open container of an alcoholic beverage in a motor vehicle. An open container is any container with a broken seal. The vehicle contained 2 wine bottles, one fully empty, one half empty. Both qualify under the statute. The subject's explanation that she consumed them at home before departing does not negate the open container violation. It does create an evidentiary discrepancy. She initially reported 1 drink at sub 15. 1 empty bottle and 1 half bottle consumed before driving produces a consumption picture that does not match that self-report. The field sobriety exercises are voluntary under Florida law. Only chemical tests, breath, blood, and urine fall under Florida statute. Section 316.1932's implied consent requirement. The officer's advisement at sub 69 that the subject had the right to say yes or no to FST was legally accurate. The horizontal gaze nystagmus test was administered and produced a negative result. No nystagmus detected at sub 247. The DUI decision is the most legally nuanced judgment in this encounter. Against the indicators suggesting possible impairment, admitted alcohol consumption, open containers, erratic driving, the officer weighed 3 indicators in the other direction. Negative HGN result. No detected alcohol odor at sub 308. And a completed walk and turn, without documented impairment findings. Under the totality of circumstances framework from Illinois v. Gates, the officer assessed the full evidentiary picture and concluded that probable cause for DUI was not established. The decision not to administer a chemical breath test was sound under Birchfield v. North Dakota in 2016. That case addressed the constitutionality of implied consent laws and warrantless chemical testing, establishing that breath testing without adequate probable cause creates legal exposure. With negative preliminary indicators, pursuing a datamaster test without sufficient PC would have risked producing a result that couldn't be used. Charging reckless driving, which was airtight, and foregoing uncertain DUI was the legally correct call. Miranda was read at sub 127 through 138, after the formal arrest decision and before substantive post-arrest questioning. The advisement was complete. The subject acknowledged understanding and waived at sub 141. Under Bergwis v. Tompkins in 2010, a suspect read Miranda rights who voluntarily continues to speak without invoking silence has implicitly waived those rights. All post-Miranda statements, including the wine bottle account and the final self-admission, are fully admissible. The search of the subject's person at sub 179 was a search incident to a lawful custodial arrest, authorized under United States v. Robinson in 1973 without a warrant, without separate consent, and without additional probable cause. The wine bottles found in the vehicle during the stop were in plain view and admissible under Horton v. California in 1990, which requires only that officers be lawfully present and that the incriminating nature of the evidence be immediately apparent.
All right, go ahead, back in the car. Where do you live at?
I live in Wesley Chapel. It's about like 45 minutes north.
So what were you doing all the way down here?
I was just going to my friend's house.
Where's your friend live?
Like 1 minute away. Like left.
Like down here on
Like,
the beach?
yeah, like right, like there.
Okay. Where, like, you still live at home with your parents and everything? Do they know what you're up to right now?
I told them because I left my mom's other pair of keys like with him, so my purse and my other pair of keys are with him. So they
With
thought I
who?
was with the guy that I'm going to see now.
I already read Miranda.
Oh, okay. Yeah. Okay. So this is a guy friend that you were going to meet.
Yeah.
So why were you? What was the point of all the driving? What was the point?
I don't know. I guess I was just trying to get home quick.
Okay. Where did you pick up all that wine at?
The store.
On the way? Did you have the one and
No,
open
I
that
already
half?
drank both of those. Like at home.
You drank them both at home before you left?
Yeah.
Okay. Because, I mean, there's one that's completely empty in there, and then there's one that's half
I
empty.
already did that test, so I don't know, like, why these questions are being asked. Like, I just want to go to jail and then get this done with. I don't know what the fuck is happening right
All right. Well, why don't you take a couple breaths, calm yourself down, all right? We were just trying to figure out what's going on, okay?
You ask her for her mother. What's your mother's number again? I guess. I don't know. I'll call her in a minute.
I mean,
All right.
Thank you.
Step out, please. All right, listen. I know I checked your eyes. I didn't see nystagmus, but if you're, chugging wine.
I'm not chugging wine.
I'm just
I'm
saying.
tired. I want to go home.
Okay, but you got open wine container.
Okay, well, we can do the whole eye thing again.
Okay, I'm gonna have you do more than that. Okay. I'm
Okay,
gonna have
that's
you do
fine.
I'm gonna have you walk the line and all that. You want to do that?
Sure, we can do that.
I'm trying to take the cuffs off you now.
Okay.
Let me turn them. All right. So I'm going to reposition my vehicle so I can get a better shot. Katie, can you walk her
you
over
can
there?
use mine if you want.
I
That's fine,
refuse
we'll do
to
it.
do this. So
You don't
can
want
we
to?
just go to the jail? Like, I'm so done with this. Like, take me to the fucking jail.
Okay.
So this is the deal.
Like, no, bro. Like, what is this?
Wait,
No,
like I said,
breathing. Like,
Yeah, you're really emotional right now.
Because this is like,
All right, here's the deal. So I'm asking you to submit to field sobriety. I already checked your eyes, okay? But there's other process to it. It's not just the eye check. There's other exercises. You have the right to say yes or no.
okay, and what happens if I say no?
And then I have to base the decision based on what I see.
Okay, well, I'm emotional because I just got arrested, maybe.
Okay, so I'm not trying to be mean to you, man, but I need an answer. Do you want to submit to field sobriety, finish the field sobriety, or do you not?
Bro, it's like whatever at this point.
I'm
like,
asking you. That's whatever's not an answer.
Sure, let's
Okay.
do this freaking test.
All right, we're gonna walk over here.
Like,
Yeah,
imagine
Yeah, I'll turn off.
you're living. That's insane.
Okay.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26,
Okay, you can stop.
27.
All right. I'm gonna walk back over to my car.
I was too distraught to hear you the first time.
All right, please place your hands behind your back. Hang on. I don't want to tighten these and hurt you, so just be careful. I'm gonna lock them before they tighten. You already checked her? Okay. Have a seat, please. I'm gonna call your mother.
How long am I gonna be in freaking jail?
I don't know. I'll let you know. You'll know more when you get
Like-
there. I won't know. You won't know till you get there. Depends on how busy they are. I'm not gonna do the DUI.
I think it's a listening issue. I don't think
Yeah.
it's a.
I don't think it's a.
issue.
Yeah.
I didn't have
I didn't see. I have yet to smell anything.
So you're gonna face them in the whole time? Or are you
Okay,
just gonna
I
sit
really
there?
have to use the bathroom though.
I get that. I'm sorry to tell you, but it's gonna be a little bit until we get to the jail, alright?
Okay, but so what do I do now?
Hold
Like-
it as long as you can. And if you can't hold it no more, then so be it. Alright, are you able to bend at the elbows at all? Yeah, there we go. Can't move your hair just a little bit while I get this ball around.
Patrol 3.
Alright, you can relax now. Like I said, we're going to move the handcuffs from the back to the front, so that way you can stabilize yourself in the truck. Yeah, it's going to be a little bit
insane. Like, what is this, Tom?
This is just procedure we do
This
this
is just like ridiculous.
thought. Actually, yeah, that might help.
Thank you.
I just stuff good in here.
Your phone, your debit card, and your citations are in that bag, okay?
Like, this is fucking insane.
This is just the transport vehicle.
She's doing 91 and a 35, and it's my fault.
The officer receives an A+. The stop was constitutionally clean. The superspeeder statute was explained accurately and without cruelty. FST consent was correctly characterized as voluntary. Miranda was read at the right procedural moment, and the DUI decision reflects genuine legal judgment rather than default charging. Throughout a prolonged emotional encounter with a distressed young person, the officer was consistent, patient, and precise. The one note, sub 175. If I give you a ticket, you're never going to learn anything crosses from legal explanation into personal editorializing. It was unnecessary and slightly paternalistic, though it created no constitutional issue. The subject receives a D, 91 miles per hour in a 35 zone, near a pedestrian crosswalk, at night, in a vehicle that was not hers. With open wine containers inside the combination produced a mandatory arrest that the subject found confusing. Her confusion was understandable. Her conduct was not. The D grade reflects the driving behavior and the legal consequences it generated, not the character she demonstrated in custody, which was cooperative and ultimately self-aware. Her final statement, "I was doing 91 and a 35 and it's my fault," is a complete voluntary admission and a rare moment of genuine accountability. 3 lessons. First, Florida Statute Section 316.1897 removes officer discretion at 50 miles per hour over the posted limit. There is no discretionary ticket pathway at that threshold. The driver who exceeds it does not face an officer deciding whether to arrest. The officer faces a statute requiring it. Understanding that this category of violation has a mandatory arrest consequence changes the risk calculation before getting behind the wheel, not after being pulled over. Second, under Berkemer versus McCarty, everything said at the roadside before a formal arrest is non-custodial and admissible. Drivers frequently believe that a Miranda warning is required before police can ask them questions during a traffic stop. It is not. The moment a driver says, "I had one drink at a roadside," that statement is in evidence without any rights advisement. The right to silence exists at that moment. It simply must be invoked. The car door is not a Miranda zone. Third, the DUI analysis here demonstrates that negative FST indicators have real legal weight. A negative HGN result, an absent odor, and no documented walk-and-turn impairment collectively pushed the totality of circumstances below the DUI probable cause threshold, despite open containers and admitted consumption. Charging decisions are not made by checklist. They are made by evaluating the full evidentiary picture. The officer's decision to charge what the evidence supported and withhold what it didn't is exactly how that process is supposed to work. Thanks for watching. Drop your thoughts on the case in the comments below, and check out Street Bodycam for more police interaction and courtroom content.